My Lords, I beg leave to ask a question standing in my name on the order paper.
My Lords, we welcome the CMA's report on their investigation into unfair terms and mis-selling in the leasehold market, and I commend my noble friend Andrew Tyree, who led this report, for his work. The report underlines the problems caused by onerous ground rents. We have been clear that leaseholders should not pay a charge for which they have received no tangible benefit in return, and that is why we've committed to legislating to reduce ground rents to zero for future leases and banning the sale of new leasehold houses. We are pleased that the CMA is seeking to take forward enforcement cases following the findings of their investigation.
Does the noble lady agree with me that the action of some freeholders, property developers and service companies is scandalous? Leaseholders ripped off with ever-escalating ground rents, service charges, permission fees and, frankly, dodgy sales practices, effectively making homeowners tenants in their own home. So will the noble lady go further and commit the government to take firm action on all these practices and stand up for leaseholders immediately? Urgent action needed now.
My Lords, the noble Lord is correct in that these unfair practices in the leasehold market have absolutely no place in a modern housing market. Neither do excessive ground rents, which exploit consumers who get nothing in return. And that is why we are reforming the system, so that it is fairer for leaseholders. In December 2019, we announced we would move forward with legislation on leasehold reform, reaffirming our commitment to making the system fairer for leaseholders. And this will include measures to ban the sale of new leasehold houses, restrict ground rents to peppercorn for future leases, give freehold homeowners equivalent rights to challenge unfair charges, and close loopholes to prevent unfair evictions. In terms of his question on what action we can take, the CMA has already announced enforcement action, and they've already said that this report is an interim report and their research is ongoing.
But my Lord, my noble friend, there is a backlog. There is a Is my noble friend aware that there is a major backlog of time? Sorry.
Minister regret that DCHLG ignored warnings about this crisis from Leasehold Knowledge Partnership back in 2015. Does she accept that those victims of what the CMA now describes as significant harm cannot wait any longer for change? Can she explain to them what happened to Sajid Javid's promise to change the law before summer 2018? Does she accept that currently leaseholders' rights continue to be sold to speculators with little government protection, from doubling of ground rents to extortionate fees to correct issues such as dangerous cladding?
I do agree with the noble lady that this has taken a long time in the gestation for this for our legislation to come forward. But we have done a number of things in the interim since Javid's report in the other place. For example, we've asked the Law Commission to undertake a series of reports, and they've started to be produced this spring, talking about standardising the enfranchisement process, so buying and extending a lease is easier, cheaper and quicker. They're also going to make it easier for leaseholders jointly to obtain the right to manage, and also review how common hold works, so it may become a viable alternative for existing and new homes. This, together with the leaseholders' pledge that we put in place over a year ago in consultation with house builders, have gone some way, but not nearly far enough, towards mitigating the effects of the actions of these house builders.
My Lords, would my noble friend please tell the House what the government is doing to prevent house owners falling into the assured tenancy trap?
I acknowledge my noble friend's significant interest and knowledge of this area from her position as in Westminster Council. The assured tenancy trap relates to properties sold as a lease, but where the ground rents due to escalation exceed the £250 threshold outside London and £1,000 in London, and then in effect the lessees becomes an assured short-hold tenancy, meaning the owner does not have the same rights as a normal owner and can be repossessed if they fall into arrears. And the government is committed to addressing this issue via legislation, which will take long leases completely out of the assured short-hold tenancy regime, which will prevent leaseholders being affected by this issue completely.
The Minister rightly condemned and regretted when homeowners were ripped off. I wonder if you would care to comment about Persimmon Homes. The average cost of a house they build is £250,000, on which they make a profit of £65,000. And a large number of their homes have already been declared unsafe in relation to fire and other matters. And yet last year, the Chief Executive received a bonus on top of his salary of £73 million. Is that not absolutely outrageous? What is the government going to do about that?
As my previous answer said, the Competition and Markets Authority report updating their investigation into the extent of mis-selling and onerous lease terms will address this issue. Maybe not the profit motive, but the consequences of their past actions. I do note that in an action for Cardiff City Council versus Persimmon, in fact, Persimmon were forced to give 55 properties sold as leaseholders on the St Helens estate back to freeholders in an out-of-court settlement, so they were given their leaseholds as freeholds for nothing. We would like to see more of this happening. Regrettably, they settled out of court before it became a court case, so we can't use that settlement as a legal precedent.
Is my noble friend aware that we recognise that the government are taking action on a number of aspects, but there remains the problem, does there not, of those couples who bought, as it happens particularly in the North and the Midlands, who want to move home and find their property is totally unsaleable. And the noble Lord who raised this question is absolutely right to raise it. And will my noble friend have a closer look at that situation? Because we really can we have a situation where young couples buy what they think is a home and they're stuck there and unable to move.
I agree with my noble friend, and that's why we're working closely with the Law Commission, with the CMA, to inform future legislation, because this really has become a particular problem to the north of England. Could I also just say, in answer to Lord Fuchs's question and to yours, that in fact what's most disappointing is the governance of the companies that have, the householders, that have house builders, that have been escalating these charges, and that in fact the job of a non-executive director of these companies should have taken a longer, harder look at their policies.